Clara Mead was 29 years old. On the afternoon, her mother-in-law left a deed on the parlor table and told her the tower was all that remained. The deed was in a plain envelope, unsealed, set down without ceremony beside the cold tea things that no one had cleared since the solicitor's visit that morning. Harriet Vane, who had been Clara's mother-in-law for 4 years, and who had, in Clara's careful observation, never performed a kind act without first calculating its cost, stood in the doorway of what had been, until 6 months ago, Clara's home. The farmhouse was already half emptied. The furniture James had inherited from his father was stacked in the hall, waiting for the carrier. The kitchen shelves had been cleared. The garden Clara had spent 3 years improving was already beginning to revert to the scraggly neglect it had maintained before her arrival, as though it understood what had happened and saw no reason to maintain standards for whoever came next. The farm had been sold. The sale had been completed with a speed that still unsettled Clara when she thought about it. The notices posted within 3 weeks of James's death, the buyer found within a month, the transfer completed before the ground had properly thawed in the spring. Harriet had said there were debts. Clara had asked to see the accounts. The accounts had not been shown. What had been shown, eventually and by the solicitor rather than by Harriet, was James's will, a document that left everything to his mother, the wife provided for by whatever his mother chose to give. Harriet had chosen to give the tower, a squat, roofless stone structure on the steepest part of the farm's eastern boundary, with perhaps 1 acre of rough and rocky ground around it. "You may sell it if you find a buyer," Harriet said, not unkindly, which was worse in its way than unkindness. "I doubt the land will interest anyone." She left before Clara could respond. Clara picked up the envelope. On the back of the deed, in handwriting she recognized as her late father-in-law's, old Henry Vane, who had died 3 years before James, and who had been, Clara had always thought, the more careful of the 2 Vanes she had known. Someone had written in pencil, so faint it was almost invisible, "Dig the tower floor." Right corner. She read it twice. Then she put the envelope into her coat pocket and began to think. Clara had worked for 5 years in the offices of Bassett and Crane, a firm of architects and surveyors in Exeter, before her marriage. Her role had been that of a copying draftsman, not a title anyone had needed to invent for a woman before Clara held it, and not one that earned her anything approaching what a man would have received for the same work, but a role that had suited her particular abilities with considerable precision. She had a steady hand, good spatial judgment, and, most relevantly, an appetite for the documentary work that many of the firm's more formally qualified men found tedious: the boundary instruments, the title plans, the property schedules, the building registration documents that formed the legal foundation beneath every structure Bassett and Crane designed or surveyed. She had spent 5 years reading these documents closely, copying them accurately, and filing them in the order that Mr. Bassett required, which was the order in which they would be needed if a dispute arose, because Mr. Bassett had spent 30 years in practice and had learned precisely when disputes arose and over what. She had also learned, across those 5 years, to read a plot of land the way a surveyor reads it, rather than the way a farmer or a buyer reads it, not for what the land looked like or what it might grow, but for where its legal boundaries fell, and on what basis they had been drawn, and when and by whom. She could look at a title plan and follow the parcel description around the boundary, matching the written instrument against the drawn lines, and identify where the two diverged. She could read a registration entry and tell from its date and form whether the title had been actively maintained or allowed to drift into administrative dormancy. She had spent 5 years learning to make these distinctions, and she had spent 4 years of marriage not using them, and she thought, On the evening she read Henry's penciled note for the third time in better light, that this might have been the most consequential error of her adult life. She had kept her notebooks from those years, the ones in which she had copied examples of boundary clause language, registration protocols, and title search procedures. She had kept them partly from habit, and partly because Mr. Bassett had told her the knowledge would prove useful in unexpected circumstances. She had not known, when he said it, how unexpected the circumstances would be. She had left the firm when she married James. James had not asked her to leave. It had simply been the natural order of things, as Clara understood them at 24, and as she understood them rather differently at 29. Sitting in a rented room with the deed on the table and her late father-in-law's penciled instruction in her coat pocket, thinking about what she still had and what she still knew how to do. The will had been legal and unambiguous. Mr. Philpott, the solicitor, had explained to Clara on the morning after the hearing. James had made it 2 years into the marriage, during a period when he and his mother had been particularly close following a difficult winter, and he had not returned to it. The farm was heavily mortgaged. Harriet had been correct about that much, though she had declined to share the precise figures. The sale had satisfied the mortgage and left a surplus that had gone entirely to Harriet. Clara had received what the will specified, whatever her mother-in-law chose to provide. Harriet had chosen the tower. She had presented the choice as generosity, as the provision of something rather than nothing, and Mr. Philpott had recorded it in those careful terms. Clara had said nothing to correct the characterization. She understood that Mr. Philpott was Harriet's solicitor, not hers, and that the purpose of the meeting had been to deliver information rather than to seek her opinion of it. That evening she read the deed from beginning to end, sitting at the table in the room she was renting from the widow in the village at 6 pence a week. The deed itself contained nothing immediately surprising. The tower described, the 1-acre parcel bounded on 4 sides, the title conveyed. But she noticed, as she would not have noticed 5 years earlier, one detail in the parcel description that required a second reading. The deed was dated differently from what she expected the farm's main title to show. She wrote the date in her notebook and underlined it twice. Then she read Henry's penciled note one more time, dig the tower floor, right corner, and packed her trowel alongside the notebooks in her bag for the morning. She arrived at the tower on a morning in early April, when the Devon hillsides were beginning to show their first green, and the morning mist had not yet cleared from the valley below. She had walked from the village, 2 miles on the lane, and then half a mile on a track that was more a suggestion of passage through the rocky upper pasture than a properly maintained path. The air was cold and damp and smelled of the wet limestone that broke through the turf on either side of her, and she could hear the valley below her even when she could no longer see it, the sound of water and wind carrying upward in the way sound carries on a Devon hillside in early spring, when there are no leaves yet on the trees. The tower came into view from below before she reached it, squat and dark against the pale sky, perhaps 30 feet high, the upper section open to the air where the roof had come down long ago. The walls were in better condition than she had expected from a distance, and she noticed this before she reached the structure itself. The limestone was well coursed, and the mortar joints were sound, at least on the south face which she approached first. She walked the exterior before going in, the way Mr. Bassett had always insisted his staff walk a structure before commenting on it, and she noted what she saw: limestone, of a quality she recognized from the firm's survey notes as above average for the region, dense and close-grained. The walls at least 3 feet thick at the base, possibly more. The stonework of the lower 2/3 considerably older than the upper courses, as though 2 different periods of construction had been joined at some point in the building's history. The door opening. No door remained. the wood gone entirely, faced east, and beyond it she could see the valley laid out below, the lane running between its stone walls, the lower fields pale in the April light, and in the distance, the gray roof of the farmhouse that was no longer hers. Inside, a stone floor, partially covered in wind-blown soil and the accumulated dead vegetation of decades. The open roof admitted a flat gray light from above and from the east. She stood for a moment and looked at the space with the particular attention she had been trained to give to interiors she had not entered before, noting the dimensions, the state of the walls, the condition of the stonework, the relationship between what the exterior had suggested and what the interior revealed. Then her attention moved to the southeast corner and stayed there. The floor there was uneven in a way that drew her eye before she had consciously registered the reason. Not the uneven settling of old stone, which she knew how to read from 5 years of surveying reports, the gradual compression of a floor that has borne weight for generations, which produced a particular kind of evenness beneath its unevenness, a conformity to the slow logic of time and gravity. This was something different. The soil in that corner was fractionally darker than the surrounding surface, and it sat at a very slightly lower level than the stone on either side, in the way that disturbed earth sits when it has been turned and replaced, but has not yet fully settled back to its original density. She crouched beside it and pressed her palm flat against it. It yielded, just perceptibly, under the pressure. She had brought a small trowel in her bag, because Henry's note had said right corner, and she was not a person who read a specific instruction and then improvised around it. She began to dig. The trowel struck something solid at approximately 8 inches. She cleared the soil with her hands, working carefully around the edges, and exposed the upper surface of a flat stone, a cut stone, not a natural one, set deliberately into the floor as a cover. It was heavy, but a single person could move it with patience. She worked the trowel beneath one edge, then slid the stone aside. In the space beneath, a brass box, approximately the size of a large ledger volume, its surface dark with age, but the metal sound and the lid's clasp intact. Clara wiped the dirt from it with the corner of her handkerchief, sat down on the tower floor with the box in her lap, worked the clasp open, and lifted the lid. Inside, wrapped in a double layer of oilskin that had kept out 30 years of Devon damp, were 2 documents. The first was a deed, 4 pages, hand-copied in a formal legal hand, dated March 1831. She read the heading, Grant of Freehold Title, Tower Parcel and Adjacent Land, Lower Branton, Devon. The grantee, Henry Vane. The description of the parcel was precise and clearly bounded. The stone tower in its entirety, together with 1 acre and 3 roods of land, bounded on the north by the farm wall, on the east by the lane, on the south by the stream bed, and on the west by the main farm boundary. And then a phrase she read very carefully, because she had seen this kind of phrase in the Bassett and Crane files and knew exactly what it meant in law. Registered as a separate freehold parcel, not included in or appurtenant to any other title. The second document was a hand-drawn map in Henry's own hand, not a surveyor's formal plan, but a careful and detailed sketch, to a stated scale, showing the tower and its surrounding acre from above. The stream bed was marked along the southern boundary. The farm wall ran along the north, but the significant feature was a mark in the southeast corner of the tower's land, precisely where Clara had dug, with Henry's annotation beside it in the same penciled hand as the note on the deed, Spring Head. Source of lower field irrigation feed. Flows beneath lane to field ditch, south pasture, and below that, underlined once, this right belongs to the tower, not the farm. Clara sat in the tower for some time after she had read both documents. The Devon light came in through the open roof above her, and fell on the brass box, and on the oilskin, and on the two documents in her hands. And she read Henry's annotation again, and thought about the lower fields of the farm she had walked across for 4 years without understanding what fed them. Then she folded both documents back into the oilskin, placed them in her bag alongside the trowel, replaced the flat stone over the empty space, and left the tower. She went directly from the tower to the cottage of Edmund Grote, the village blacksmith, a man of 70 who had shod the Vane Farm's horses since before Henry had bought the land, and who had, in Clara's 4 years of living in the valley, a precise and entirely unsentimental memory for anything that had occurred there in the past half-century. He was in his yard when she arrived, working on a gate hinge with the unhurried concentration of someone who had never seen the benefit of rushing a metal joint. She waited until he set it down, and then she showed him Henry's map and explained what she had found beneath the tower floor. He listened without interrupting. When she pointed to the spring head annotation and the note about the irrigation feed, he was quiet for a long moment, looking at the map rather than at her. "Henry told me about that spring," he said finally. "Long before he died, said the whole south pasture depended on it. The feed runs off the spring head, goes underground under the lane, comes up in the field ditch, and carries water to the bottom of the holding, all through the dry months." He handed the map back. "Alderton, the man who bought the farm, he's been running that irrigation channel since he took possession in January. Every day, as far as I can tell." Clara asked if Henry had ever mentioned the tower deed to anyone other than Grote. He said he did not believe so. Henry had been a private man, he said, and deliberate about what he shared and with whom. Clara asked why he thought Henry had buried the deed, rather than filing it among his papers at the farmhouse. Grote looked at her steadily. "Because he knew what Harriet would do with it if she found it," he said. "Nothing deliberate. That wasn't Harriet's way. She'd simply not have understood what it was, and she'd have sold it or misfiled it or given it away with the rest of his papers. And the deed would have been gone." He paused. Henry wasn't a man who trusted to carelessness. He trusted to the right person finding what he'd left, if he pointed them clearly enough. He looked at her for a moment. He was right, it seems. Clara spent 2 days at the county land registry in Exeter the following week. She found the 1831 registration in the parcel records without difficulty, a separate freehold, Henry Vane, tower and adjacent land, Lower Branton, registered March 1831. The parcel had never been transferred, never mortgaged, never incorporated into any subsequent transaction involving the farm. When the farm had been sold 3 months ago, the tower parcel had not been part of the conveyance, because it had never been part of the farm title. It had been Henry's private holding from the beginning, under the terms of James's will, which had offered Clara whatever the mother-in-law chose to provide. Harriet had offered it without. Clara was now certain, understanding that it was the only thing she had no authority to withhold. The spring head, the drainage records confirmed, fed an underground course that surfaced in the lower field irrigation ditch, currently running on the land of Mr. George Alderton, who had purchased the farm from Harriet in January. Alderton was using the irrigation system, which meant Alderton was using water from a spring that sat within Clara's registered freehold, and over which, under the terms of Henry's original deed, the tower parcel held sole water rights. She went to see Mr. Crail, a solicitor in Exeter, whom Edmund Grote had recommended as a man who charged fairly and did not speak more words than the situation required. His offices were modest, and his manner was direct, and he read the deed and the registration copy Clara had made without any expression beyond the focused attention of someone who is reading something carefully. When he set the documents down, he asked 3 questions. Was she in possession of the original deed? Had any instrument transferred the parcel out of the Henry Vane title, and did she have documentary evidence of the Springhead's location within the parcel boundary? She answered yes, no, and yes. Crail said the title was sound. The Tower parcel was a separate freehold. The water rights were attached to the land within the parcel boundary, and Clara was the registered holder as of the 1831 registration. The complication, he said, was the dormant status. The county's registration procedures required periodic confirmation of title for inactive parcels, and the Tower registration had not been renewed since Henry's death. This was an administrative matter rather than a substantive one. The title had never been abandoned or surrendered, and dormancy was not the same as forfeiture. But Harriet's solicitor would almost certainly file an objection on grounds of administrative lapse if Harriet became aware of the situation, because it was the only ground available to her, and because solicitors in such situations were obliged to use whatever ground was available, however weak. A formal response would be required before the county registrar. The filing fee for such a response was £3. Clara had £1 and 14 shillings. She went to Grote that same evening. She did not ask for charity, and she did not frame it as a personal difficulty. She sat in his kitchen and explained the fee, the timeline, and the likely outcome clearly. And she told him that if the title was confirmed, she intended to license the water rights to Alderton at a fair annual rate, and would repay him from the first year's income, in writing and before the registry filing was made. Grote listened without speaking until she had finished. Then he said he had known Henry Vane for 50 years and had never known him to point someone in the wrong direction, and went to the back room and came back with £2 in a cloth bag and set it on the table. Harriet learned of the registry claim within the week. Clara had not expected to keep it quiet, and had not tried to. Harriet's solicitor filed the objection 14 days after Clara's application. The 1831 registration had lapsed through non-renewal. The Tower parcel had been effectively absorbed into the farm, holding through 30 years of joint management and continuous occupation, and the title should be treated as having reverted to the farm estate at the point of administrative lapse. Crail's response was 4 pages and entirely sufficient. The 1831 deed was explicit on the separate freehold status, not included in or appertinent to any other title, language that permitted no ambiguity. No instrument existed to transfer the parcel into the farm holding at any point between 1831 and the present. The farm sale conveyance from January did not include the parcel, because the farm's own solicitor had either recognized it was excluded or had conducted a title search that revealed no basis for its inclusion. Administrative dormancy in the registry record was not abandonment of title, and abandonment of title required affirmative evidence of intent to surrender, of which none existed. The objection rested entirely on the assertion of joint management, and joint management of adjoining land, however long continued, did not constitute a legal transfer of title in the absence of a conveyancing instrument. The hearing before the county registrar was set for a Thursday morning in June, 6 weeks after Crail had filed the application. Clara sat beside him at the long table in the registry's hearing room, a plain and unremarkable room that managed to feel smaller than its dimensions because of the quantity of paper it generally contained. She had placed the brass box on the table in front of her, empty now, the oilskin and both documents before the registrar, because she felt its presence was appropriate. Mr. Bassett had told her once that in a documentary dispute, the physical objects mattered as much as the written arguments, because a registrar who could see where a deed had been kept and how it had been preserved was a registrar who understood something about the intention behind its preservation. Clara thought Henry would have agreed with that. Harriet sat on the other side of the table with her solicitor, a capable-looking man in a good coat who had the expression of someone professionally accustomed to making the best available argument rather than the best possible one. Harriet herself looked at the middle distance and did not look at Clara, which Clara read as the expression of a woman who had recently been given a candid assessment of her morning's prospects by her own counsel. The registrar examined the 1831 deed with care, reading the parcel description and the separate freehold notation twice before setting it beside the registration copy. He examined the farm sale conveyance from January and compared the parcel descriptions. He asked Harriet's solicitor one question: did any conveyancing instrument exist that had formally incorporated the tower parcel into the farm freehold title at any point between 1831 and the present date? The solicitor said the argument rested on the long-standing joint management of the two holdings and the practical incorporation of the tower land into the farm's operation over 30 years. The registrar said that was not an answer to his question, and wrote something in his notes, and the essential substance of the hearing was concluded at that point, though it continued for a further 40 minutes in the manner that formal proceedings continue when their outcome has been determined by a single document that no one can explain away. The registrar's determination was delivered verbally before the parties rose and confirmed in writing within the week. Clara Mead was the registered freehold holder of the tower parcel and its associated water rights, with the title renewed and confirmed on the present date, and the administrative dormancy resolved as of the same. Outside on the Exeter Street, Harriet paused briefly at the foot of the registry steps. Clara waited to see if she would say anything. She did not. She walked to her carriage without looking back, and was driven away, and Clara stood in the June sun on the Exeter pavement and felt not triumph and not vindication, but something quieter and more enduring, the particular satisfaction of a parcel correctly bounded, a record set to rights, a figure that has been in the wrong column for 30 years and has finally been moved to the correct one. She wrote to Alderton the following week. She had spent 2 evenings calculating a fair annual rate, using the drainage records she had copied at the registry, the volume of water flowing through the channel, the acreage it served, the going rate for water easement licenses in the county that she had found in the Bassett and Crane notebooks under a heading her former employer had labeled simply Valuation References. She wrote a brief and businesslike letter naming the rate she had arrived at, explaining its basis, and asking for a reply within the fortnight. Alderton's solicitor replied in 8 days. His client had taken advice, the water rights claim was valid, and the proposed rate was acceptable. The license agreement was signed by both parties before the end of the month. Clara filed it in a card sleeve alongside the 1831 deed and the registration confirmation. She also wrote to Harriet. The letter was 4 sentences long. It informed Harriet that the water license had been agreed with Alderton at the rate Clara had set, that the first year's payment would be received in October, and that Clara hoped the arrangement would be conducted without further difficulty. She did not offer sympathy, and she did not ask for acknowledgment. She received no reply, which she had not expected and had not required. By autumn, the tower's ground floor had been cleared and properly assessed. Clara had engaged a local mason named Ferris, who had known Henry Vane by reputation across 30 years of Devon stonework, and spoke of him with the precise respect that practical men reserve for other practical men who understood materials, to examine the structure and give a written opinion of what restoration would require and what it might cost. Ferris spent a morning at the tower, tapping walls and measuring courses, and reading the stonework in the way that someone who has spent a lifetime working with limestone learns to read it. He said the lower courses were medieval in origin, older than the upper sections by perhaps 200 years, and were laid to a standard he encountered rarely in domestic work. The structure would stand for several more centuries without significant intervention if the roof were rebuilt to keep the rain off the interior. He wrote his findings in a brief report, which Clara filed alongside the deed and the license agreement, and named a figure for the restoration work. Clara noted the figure in her account book and set it beside the column she had begun for the projected water license income over 5 years. The arithmetic was not complicated. The tower would not make her wealthy in any rapid sense. But it would provide, and it would be hers, and the account book would balance, which was, in Clara's considered view, precisely what an account book was for. Grote's £2 had been returned in October with a small addition that he accepted without comment and without ceremony, which was the most gracious way he knew to receive a thing he had not done for the money. Crail had been paid. The account book was current and correct, entered in the small, even hand Clara had developed at Bassett and Crane over 5 years of copying documents that other people found too tedious to read all the way through to the last paragraph of the 3rd page. The brass box sat in the southeast corner of the tower's cleared ground floor, not buried, because it had been hidden long enough, and because nothing in it needed hiding any longer. Henry's map lay folded inside it. His annotation was still entirely legible in the June light that came through the cleared doorway. This right belongs to the tower, not the farm. He had been correct. He had required only that someone come, eventually, with a trowel and the habit of reading carefully, and confirm it. There is something in Clara's story that I find myself returning to long after the telling is done. It is not the tower, and it is not the water rights, and it is not even the brass box, though all 3 of those things matter to the story in ways that are obvious and necessary. It is the image of Henry Vane in his last years, writing that penciled note on the back of a deed and then sealing it in oilskin and placing it in a brass box and burying it under a cut stone in a tower floor, and doing all of this with the quiet confidence of a man who believed that the right person would come and find it and know what to do with it. He could not have known when. He could not have known that Clara would be the one, that a draftsman's daughter from an Exeter surveying firm would marry his son and lose everything in a courtroom and then walk up a Devon hillside with a trowel in her bag because she had read an instruction carefully. He had only known that someone, eventually, with the right kind of knowledge and the right kind of patience, would follow the direction he had left. He had been entirely correct about that. He had simply required someone to come and confirm it. And Clara had needed to lose almost everything before she discovered that what she had kept, 5 notebooks from 5 years at a surveyor's table in Exeter, and the deeply ingrained habit of reading every document to the very end of the final page, was precisely enough. It is not the tower, and it is not the water rights, and it is not even the brass box. It is Henry Vane writing a penciled note on the back of a deed 30 years before Clara was born, and trusting, not to luck, not to chance, but to the specific possibility that someone would one day come to that corner with the habit of reading what was written and the knowledge to understand what they found. He had been right about that. He had simply had to wait rather longer than he might have wished. And Clara had needed to lose almost everything before she discovered that what she had kept, 5 notebooks from 5 years at a surveyor's table, and the patience her father-in-law had counted on, was precisely enough. If that kind of story is one you find yourself returning to at the end of a long day, I would very much welcome you among the listeners here. There is a subscribe button nearby, and pressing it costs nothing and means the next story will find its way to you directly. And if you are inclined to leave a comment, I would be glad to know. When Clara opened that brass box on the tower floor, what do you think she felt first? Relief or certainty? Because I have always thought it was certainty. The relief came later. The certainty was there the moment she read Henry's note. Thank you for listening. I will see you in the next story.